Now available on Tata Sky channel number 526.
If you're facing any issues while buying a property, be it delay in possession, deficiency in service, or merely the developer not delivering what he's promised, call or write in with your problems and we will help you get the best legal advice possible on the show. You're watching Property Hotline with me, Kavita Krishnan, on Magicbricks Now, India's first property channel. We have a very special guest on the show today. We have Nirav Jani. Nirav is a senior associate of Hariani Co. He will give an answer to all your legal questions today. Anil Tejwani has already called in. Anil, go on, tell us what's your question.
I had booked a property in Karjat in March, and they promised me that they'll start the building work within 2 months. Till date, they have not started anything, and I tried to contact the builder. He's giving me all rosy pictures that we are going to start and we'll do very shortly and other things. What should I do in that case?
When did you buy this property, Anil? You said March. Is this March 2015?
Yeah, 2015 March.
Okay, so it's almost a year since he's bought the property, Nirav, and no work has started as yet. What should he do?
So he must write to the builder on record and seek an answer as to what is the reason for the delay. In the event he does not get an answer or satisfactory answer, then he should seek for refund of money along with interest instead of waiting further.
Okay, and say the builder refuses to refund the money, then?
Then he must immediately approach the court.
Okay, so this letter that, when he approaches the builder, you suggest he writes a letter, and should he have a copy? So in that case, should he, use registered post or something like that?
Yes, because it is prudent, because if he's booked the flat in March, and and I'm presuming there's a time period that is prescribed in the agreement within which the flat is to be delivered, and arguably there would be some sort of construction that should have been done by now. And if it is not done, then the builder should be given an opportunity to explain as to why there's a delay. Because at times there may be delays due to force majeure events. So he must seek a response as to what is the reason for the delay. And if he is not satisfied with the answer, or if there is no answer, then he is entitled to seek refund on the ground that the building may not be constructed within the period that it should be.
Okay. Anil, one more question over here. Have you signed an agreement with the developer?
No, not yet. Not at all.
So what do you have as proof of the purchase?
I have given the all-in check payment and I've got the receipt of the builders. I've paid total 8.5 lakhs to him so far.
He's paid 8.5 lakhs. He's got a receipt from the builder. Now, tell us this, Nirav. This is what happens in a lot of cases, especially when you buy under construction property or property at the launch stage, pre-launch stage in that sense. Builders just give you a receipt. Now, does that receipt stand up in a court of law?
As presuming the property is in Maharashtra, it's about 20% of the amount. If it is paid, they need to have a registered agreement. An amount below that, the builder can do you can enter into an agreement with a non-registered agreement. So yes, it would be if at all there is some sort of a writing which says that the money is towards this flat and there's a description of the flat, then it would constitute a contract to that extent. But the difficulty that you would face in this case is that there would not be any timelines prescribed as to when the building will be completed, what is the provision in case of delay, so on and so forth. So then in those cases, he will have to sort of create those grounds by way of correspondence, wherein a builder must have told him some sort of an indicative guideline of completion orally, that he will have to put it on record and ask the builder to respond and accordingly take it forward.
So Anil, essentially what Nirav is telling here is that you need to create a paper trail, you need to have some documents in place. You do not have an agreement to show in a court of law. So technically you have nothing in writing from the builder, especially as far as timelines is concerned, so you need to build up that paper trail, you need to get it from the developer in writing that he intends to start construction by so and so date, and deliver the project by so and so date. Only once you do that, then you can actually approach the court. Okay? Moving on, we have Deepak, who's written in through our website. Now, Deepak has a 3 BHK flat that he leased out to a family for 3 years in 2012. The flat is worth 6 to 7 crore rupees. He received a rent of 1,20,000 a month from this flat. Now, the lease expired in 2015 and was in the couple's name. The couple asked him to renew the agreement for another 15 months. The renewed agreement is now on the wife's name. Now they want the agreement to be made in the husband's name. He says that if I renew it now, will the duration of the lease be 5 years, or will every lease be counted separately?
So, basis the term of 3 years, I'm presuming that it is a leave-in license agreement, and I'm presuming that it is in the state of Maharashtra. Currently there would be an existing agreement in the name of the wife, because that's the renewed agreement. If they want the agreement to be in the name of the husband, the earlier agreement will have to be cancelled, and then a new agreement will have to be entered into. And as far as the term of the agreement is concerned, they are all counted separately.
So they are essentially 3 separate agreements.
Yes, but he cannot enter into an agreement simultaneously with the husband and the wife when an agreement is existing. So if they choose, if the licensee chooses now to have the agreement in the name of the husband, then they should cancel the earlier agreement and have a fresh agreement for the remainder of the term in the name of the husband. And of course, there would be some costs involved with respect to stamp duty and registration charges, which will be as per commercial understanding between the parties.
Between the parties, right. So Deepak, it will be a separate lease agreement that you will have to make. But before making that lease agreement, ensure that you cancel the lease agreement that you already have with the wife. Moving on, Sagar has called in. Sagar, tell us what's your question.
Hello, yeah.
Yes, Sagar.
Hello, yeah. Can you hear me?
I can hear you. Tell us what's your question.
Okay, I want to know the procedure of registration. What are the steps that I need to follow if I buy a flat?
If you buy a plot of land. Sagar?
Hello, yeah.
Yeah, you want to know the registration procedure if you buy a plot of land.
Yeah, exactly.
Okay. Where are you buying this plot of land?
Mumbai.
In Mumbai.
Yeah.
Okay. So so this is basic 101 over here. Nirav, tell Sagar what he needs to do if he wants to register a plot of land.
So the prerequisite to that would be a document that he desires to register. That document will have to be stamped with the appropriate stamp duty as per the Maharashtra Stamp Act of 1958. Once the stamp duty that has been affixed on the document is of the nature that is prescribed, then there is a form that the sub-registrar's office issues, which is available online. That form will have to be filled in with all the details, with the purchaser, seller, the consideration, the amount of stamp duty, the details of the property, etc. Then that form needs to be submitted to the sub-registrar's office. You would then be generated some sort of a token which you have to take when you desire to have your document registered. And the first process at the registration office is that the document gets scrutinized from the perspective of payment of stamp duty and whether all the other procedural aspects of the document, for example, the photograph of the seller, the photograph of the purchaser, the thumb impressions, the signatures, so on and so forth, are complied with, and then the document gets registered.
You know, Nirav, typically when you go to a stamp duty or the registrar office, there are a lot of agents over there, and I know that, a lot of brokers also offer this service. Now, the broker is obviously offering the services as part of the entire property buying service. But what about the agents? Is it advisable to go through these agents, or would you rather advise that the person does it themselves? And is it easy enough for an individual to go and do it themselves?
I believe the forms that are issued and which need to be filled in, which are issued by the sub-registrar's office, are in Marathi. So if you're not well conversant with the language and you're not well conversant with the subject, then it would help to speed up the procedure, because the sub-registrar's office works in that procedure. So if you have some defects, they will ask you to rectify and then come before they register a document. So if you are not having experience or if you're not having knowledge, then you might have to make 2 or 3 visits before your document is complete in all aspects. What a person who has got experience may assist you in maybe speeding up the process and cut down the delays maybe.
Okay, so you can take the help of an agent if you want to register a document and you're not very conversant with either the language or the procedure. We now have SC Srivastav who's joined in on the phone. Mr. Srivastav, go ahead, tell us what's your question.
Yes. Just a minute.
Mr. Srivastav, can you hear me?
Just a minute. Yeah. Just a minute.
Sure.
Magicbricks. एक minute. Hello.
Yes, Mr. Srivastav, go ahead. Tell us what's your question. Mr. Srivastav?
Are you getting it?
Yes, I can hear you loud and clear. Tell me what's your question.
My question is that I booked the flat in 2010.
Okay.
And the builder promised me to give delivery within 2 years.
Okay. Where did you book the flat, Mr. Srivastav?
This is in Paras Builder, Noida.
Okay.
So, after passing more than 5 years, he had not yet, very recently he offered the possession. Very recently. Okay?
Okay.
So, I am residing in renting a house and I paid the down payment to him.
Right,
Okay.
Mr. Srivastav? Yeah.
So, I am suffering from and I paid the down payment, so my interest amount is going to waste and rather I am paying the rent also.
And you've not yet got possession. You said he's recently offered possession.
Yeah, he recently offered maybe after 5 years, recently he offered.
You want to know if you can recover the interest from him for the delay.
Yeah, I want to know the recover of my interest, thus the rate of this my rent is I am paying. So, what is the source I can claim him and I can take my money and mental agony and lot of suffering.
Right, Mr. Srivastav. Let's get Nirav in over here. Nirav, he booked a flat in 2010. He was promised possession in 2012. Has been delayed by 3 years. He's been offered possession now. But he obviously wants to ensure that, he has been paying rent. He's been paying his EMI. He wants to know if he can claim damages here.
I'm presuming that Mr. Srivastava must have entered into an agreement with the developer. In the event he has, then there may have been some sort of consequence or clauses stipulated in the event of delay caused by the developer in handing over possession. In the event there is, then he will be governed by those clauses. In the event there isn't, or he feels that
Which is generally the case, Nirav. Most agreements don't have a clause as to what the developer will do in case of a delay.
So, in the event there isn't, then there would be a breach of that contract because he's not delivered the possession within the stipulated period, in which case you can claim compensation, or if you want, you can resign the contract.
Okay. So, when you say that you can resign the contract, what does that mean?
Means you can terminate the contract.
Which means he won't have the flat and he won't have the money.
No, he can. Of course, the consequence of termination is to seek the refund of the money along with interest and damages and compensation that you feel you are entitled to by virtue of termination because of the breach.
But he can take possession of the flat and also ask for damages. Is that possible?
Like I said, if there isn't anything stipulated in the agreement, then he'll be governed by the judicial precedents, if any, in case of delay that the developers have caused in handing over, and him justifying the agony, mental agony, the interest and the other expenses that he is incurred.
So it is possible, Mr. Srivastav, you can go to court, you can take the developer to court, and you can also take possession of that flat and take the developer to court and claim damages. You can do that. What would you advise, Nirav? Should he go to consumer court over here, or should he, take the civil route?
He must take the physical possession of the flat if it is ready, and he must at the same time raise a protest saying that though I'm accepting the physical possession right now, it should not be termed as I am giving a go-by to the delay. and keep that right with him to seek compensation, and then he can approach a consumer
How
court
does
or
he
a civil
raise this
court.
protest? He has to give something in
letter.
writing?
Yes, because there will be some sort of a letter exchange that the physical possession has been handed over. At the same time, he must raise a protest by saying the physical possession has been handed over delayed by X number of years, and you're raising a protest to that, and you will and you reserve your right to deal with that if there is any claim for compensation. Because
Right,
at times, if you do not raise any protest, then there's a possibility of a defense by the developer saying that you have acquiesced and you have chosen to waive that right of yours.
Key point coming in over there, Mr. Srivastav, you can take possession. In fact, it's sensible to take physical possession of the property that is being offered to you. And at the same time, when you are taking possession, ensure that you raise a protest. Take it, give it to the developer in writing that the possession is delayed and that you retain the right to actually claim damages over here. We have Arush Gupta who joins us on the phone line. Arush, tell us what's your question.
Yeah, I had purchased an investor flat in October 2013 in a 85% completed project in Mira Road.
Okay.
That time builder had told I will give the possession in 2014 December. Till now he has not given any possession, and after 85% paid, 7% more I had paid in between this time. And then now he has not given paid. So what to do right now? Should I go to consumer court, or should I wait for till my possession and then after should I go to that? Because it will take if I go to court, and then it will take long time. And I think it is around 1.5 years more it will take to give possession. So what is good for me?
Has the developer told you that another 1.5 years to possession?
I am thinking. Developer has not said anything right now. Construction is going on for last 3 years.
Is there construction activity that you can see on the site, Arush?
Yeah, it is right now going on. For 2 years, it was not anything happened.
Okay, let me get this right. You paid 85 lakhs plus.
Very well reputed builder in Mira Road. So, and very luxury flat. That project is also luxury. So, what to do right now? I am paying rent right now also. And I for 2 years, 2.5 years, I am waiting for that. October 2032 till now.
Right. Arush, you paid
93. I have paid 93% amount to the builder.
92% is what you've paid. 93% amount you've already paid.
Yeah.
But let me get this clear. You bought an investor flat.
Investor flat allotment was transferred to me, and registration was done in February 2014.
Okay. Let me get Nirav. When Nirav, he's bought an investor flat, the allotment has been transferred to him. He's paid 93% of the cost of the flat. Can he actually take the developer to court? What are his rights here?
Yes, he can take the developer to court since he has registered an agreement. If there is any consequences for delay in delivery of possession, then he must follow those consequences, and he can also approach the court now also saying that there is a delay, and in the event of delay he should be compensated with an X amount of rupees, for example the rent that he's paying for staying in alternate accommodation.
Okay, so essentially you're saying that Arush can go to court and get an order saying that the developer pay rent till he gets possession of the flat.
In the event there is no consequences or there is no other stipulations in the agreement.
Okay, Arush, you'll have to go through your agreement, or you'll need to get a lawyer to, read through the agreement very closely. In case there are no other consequences that have been clearly mentioned in the agreement, which gives the developer an upper hand, you can go to court and you can actually get an order where the developer has to pay rent to you until and unless he gives you possession. Okay? Moving on, we have Rakesh Chopra who's called in. Rakesh, what's your question?
Hello. Good evening. This is Rakesh from
Good
Mumbai.
evening.
Yeah, question is actually we have a property in Himachal Pradesh, Solan, which we bought in 2011.
Okay.
And this property was already with the bank on lease, but the lease expired 2 years before we bought. So when we we bought it, there was no lease agreement, but the bank was already there, and we also negotiated and discussed with them for continuation of the lease period. Actually, this property, two brothers owned half and half with separate, you can say, titles, and I bought it from one of the brothers, half portion. So the total portion, that is myself plus other person, both are with the bank, and we leased it out.
Rakesh, sorry to interrupt you. You have bought one half of the property.
Correct,
am I right?
Correct.
Okay, go on.
So then, as the lease was expired earlier than 2 years earlier than when we bought, we tried to finalize with the bank whether you vacate the premises or you continue with the market rate. But they were not ready, and the negotiation went on.
Okay.
And in between, whenever there was a point to finalize, they were creating some kind of unnecessary problems by telling that no, first you get the repairs of the property done, first you get this done, that.
Right.
Actually, ultimately, it was proved that nothing was to be done. So finally, when the new regional head came, he agreed and he said, "This is this price maximum we can give."
So Rakesh, what we have other callers waiting. So be very quick about this. What is your question then?
Question is, they paid the final amount of rent, which finally the agreement was signed in 2014, and that too at a lower rate, but we signed it, and but the payment was made in March 31, 2015.
Okay.
So we want the bank to pay the interest as they have done a lot of delay of more than 4 years.
You want the bank to pay the delay for the lease, for the rent that was supposed to be paid to you.
Actually, the arrears were paid on March 31st, 2015.
Okay.
So we want them to pay the interest for the 4 years delay.
Okay.
And we have represented with the bank many times. We have talked to all their senior people.
Right. You need to know whether you can take legal action against the bank.
What action we can take? Do we have a case and what to do?
Okay, Rakesh. Nirav, what can they do? It's a very interesting case. The point is that there are two owners over here of the same property.
So when the settlement or the extension talks were going on, and when the final amount arrived at them paying for the 5 years, if there was an agreement that because there's been a delay for 4 years, you are also liable to pay the rent with interest, then he's entitled to claim interest.
Is there such an agreement, Rakesh?
We have signed a lease agreement for 15 years.
No. Has the bank in the agreement, has the bank agreed to pay arrears with interest?
No bank agrees. Nobody will sign such an agreement.
So what can he do now, Nirav?
Secondly, I believe that they have already accepted the rent. And if the rent has been accepted without protest, that the interest is due and payable, then in that case it will be very difficult for him to claim interest.
Okay. So Rakesh, if you've already accepted the rent, then it's going to be very difficult. If not, then you can register a protest by sending a legal notice to the bank, by actually giving the bank in writing that they also owe you arrears in the form of interest, and then you can actually take legal action on the bank. With that, we are completely out of time on today's show of Property Hotline. Thank you very much, Nirav Jani, for coming in, for answering all those questions. Meanwhile, if you have any more questions, anything to do with legal issues, with tax, with home finance, or with just buying, selling, or investing in property, send in those queries. You know how to reach out to us. You can write in to us on email, on our website www.mbnow.in, or on our Facebook page. You can also tweet to me. I'd love to hear from you, or else just call in live like all the other callers you saw on this show. Thank you very much for tuning in. Keep watching Magicbricks Now.